et en temps voulu. Avant de continuer, je vous invite à vous lever et à observer une minute de silence consacrée à la prière ou à la méditation, notamment pour les victimes. Je vous remercie. Before turning to the substantive issues, I would like to provide you with some practical information. We also have to take some purely procedural decisions to ensure the proper functioning of the Assembly. Following a drawing of lots at the 13th meeting of the Bureau on 3rd of September 25, in accordance with the decision ICC-ASP/1/decision 4 of 3rd September 2002, the delegation of Gambia will take the first place to my right, with the other delegations following in the English alphabetical order. Each state party will be allocated 2 seats with microphones and 2 seats behind. The other delegates from state parties are invited to sit in the seats at the back of the room or at the balcony. For observer states, as well as other observers, participants and guests, in accordance with rules 92, 93 and 94 of the Rules of Procedure, seats are also reserved at the back of the room. NGOs are invited to take their seats in the gallery. Distinguished delegates, in accordance with Article 112, paragraph 1 of the Rome Statute, states that are not parties to the statute but have signed either the statute or the final act of the Rome Conference may participate as observers in the Assembly. Observer states are allowed to participate in the deliberations of the Assembly but may not participate in the taking of decisions. Those states that are not parties to the Rome Statute and that have not signed the final act or the statute do not have observer status. Rule 94 of the Rules of Procedure provides that at the beginning of each session of the Assembly, the President may invite those states to be present during the work of the Assembly, subject to approval from the Assembly. I propose that the Assembly invite the following states which do not have observer status to be present during the Assembly's work: Bhutan, Democratic People's Republic of Korea, Equatorial Guinea, Eswatini, Lao People's Democratic Republic, Lebanon, Mauritania, Federal States of Micronesia, Myanmar, Niue, Palau, Papua New Guinea, Rwanda, Somalia, South Sudan, Tonga, Turkmenistan, and Tuvalu. May I take it that the Assembly wishes to invite these states to be present during its work? I do not see any objection. It is so decided. As already mentioned, seating has been reserved for observer states and invited states. Seating has also been reserved for NGOs invited under Rule 93 of the Rules of Procedure. Distinguished delegates, the provisional agenda is contained in document ICC-ASP/24/1, and an annotated agenda is contained in document ICC-ASP/24/1/addition 1. May I take it that it is the wish of the Assembly to adopt the agenda as contained in document ICC-ASP/24/1. I see no objection. The agenda contained in document ICC-ASP/24/1 is adopted. Excellences, Distingués délégués, j'ai l'honneur de faire rapport sur les activités menées par le bureau de l'Assemblée cette année. Dans un souci de gain de temps, je me contenterai de souligner certains aspects contenus dans le rapport complet qui sera inclus dans le document officiel de cette session. Je tiens tout d'abord à exprimer ma gratitude envers les deux vice-présidents de l'Assemblée, l'ambassadeur Michael Imbrancanu du Sierra Leone et l'ambassadrice Margareta Kasangana du Pologne, pour leur travail en soutien au bureau et en tant que coordinateur du groupe de travail de New York et du groupe de travail de La Haye, respectivement. Je souhaite également exprimer ma gratitude pour le soutien apporté par le secrétariat au travail de la présidence du bureau et de ce groupe de travail, ainsi qu'à tous les titulaires de mandat à New York et à La Haye. Le recrutement du directeur du secrétariat, avec l'aide d'un comité de recrutement, a été un sujet important pour le bureau en 2025. La nouvelle directrice, Mme Gabrielle McIntyre, a pris ses fonctions en mai 2025. Je lui suis reconnaissante pour toute l'aide apportée durant ces premiers mois. Entre les sessions, le bureau a tenu 16 réunions pour aider l'Assemblée à s'acquitter de ses responsabilités en vertu du statut de Rome. En janvier 2025, le bureau a attribué à ces groupes de travail les mandats décidés lors de la 23e session de l'Assemblée et a nommé des facilitateurs et des points focaux pour 2025. Le bureau apprécie vivement le travail. Au cours du premier semestre de 2025, le bureau a été engagé dans les préparatifs de la session extraordinaire sur l'examen du crime d'agression tenu à New York du 7 au 9 juillet 2025. Le président du groupe de travail sur les amendements, l'ambassadeur Juan José Quintana de Colombie, a joué un rôle clé dans la préparation des bases pour les discussions lors de la session extraordinaire. Et je souhaite lui exprimer ma plus sincère reconnaissance pour les efforts qu'il a déployés afin de garantir que la session extraordinaire aboutisse à un consensus. Nous disposons désormais d'une feuille de route claire pour les discussions futures sur les questions importantes. The Bureau has regularly monitored the status of contributions to the budget of the Court and considered ways to better address the problem of outstanding contributions and arrears. In particular, the Bureau assigned the development of the criteria for the waiver of a loss of voting rights to the Budget Management Oversight Facilitation, noting the need to make progress on developing criteria. The Bureau recommended to the Assembly the granting of waivers to 5 states parties for the purpose of the special session. At its 16th meeting on 26 November 25, the Bureau recommended that the Assembly grant requests for waivers from the loss of voting rights to 1 state party at the 24th session of the Assembly, while recalling that the Budget Management Oversight has, throughout the intersessional period, worked on the development of agreed criteria for assessing such waivers in the future. I note that at this difficult moment for the Court, it is critically important that states parties pay their contributions as soon as possible. I would like to take this opportunity to express my appreciation to those states parties that have paid their assessed contributions to the 2026 budget in advance in response to the request made by the Registrar. I once more urge all states parties with outstanding contributions to make every effort to settle the outstanding balances as soon as possible. Throughout the intersessional period, the Bureau has been occupied with questions related to the investigations carried out by the Office of Internal Oversight Services, OIOS, into alleged misconduct by the prosecutor. As of today's date, this investigative fact-finding report is still pending, and the OIOS has consistently maintained that the investigation is a priority for it. At its 4th June 2025 meeting, the Bureau agreed on the establishment of an ad hoc panel of 3 external judges, each acting in a personal capacity. The panel will have an advisory role in relation to the Bureau and will focus on the legal characterization of facts in the OIOS report. The panel will operate independently, upholding due process, confidentiality and integrity. I note that the decision of the Bureau to appoint a panel of legal experts to undertake legal characterization takes into account discussions on the recommendations of the facilitation, on the review of the operational mandate of the independent oversight mechanism, and the study group on governance, which throughout the intersessional period considered the implementation of the independent expert review recommendation R108. I'm well aware that states have been frustrated with the length of this process, but I must underscore due process is and must remain the paramount consideration in the conduct and the conclusion of these proceedings. States parties will be advised in due course of the next steps in the matter. It is the responsibility of the Assembly under Article 112, paragraph 2 of the Rome Statute to consider, pursuant to Article 87 of the Statute, any question relating to non-cooperation. As requested by the Assembly, I have engaged throughout the year actively and constructively with all relevant stakeholders in accordance with the Assembly procedures relating to non-cooperation. At this 13th meeting of 3rd September 25, the Bureau considered the 24th of July 25 decision of the pretrial Chamber 1 regarding Hungary's non-cooperation in the situation of the State of Palestine. After hearing from Hungary's representative, the Bureau decided that the non-cooperation should be addressed at the 24th session of the Assembly. The Assembly decided at its 2024 session to include on the agenda of future sessions of the Assembly the consideration of non-cooperation issues arising during the intersessional period. The first special session on non-cooperation will have a particular focus on prevention of non-compliance through timely and effective consultations in accordance with Article 97. The protection of the court, its officials and those cooperating with it remains a top priority for the Presidency and the Bureau. It is essential that the Assembly strive to protect the court from attacks and ensure that it preserves its integrity, impartiality and independence. The strategy adopted by the Bureau on 29th July 22 for responding to attacks against the court, its officials and those cooperating with it was applied to confront attacks faced by the court during the intersessional period in 2025. On 23rd January 25, the Bureau issued a statement in support of the independence and impartiality of the International Criminal Court and reiterated its commitment to uphold and defend the principles and values enshrined in the Rome Statute and to preserve its integrity undeterred by any threats or measures against the court, its officials and those cooperating with it. I also issued personal invitation to the ministers of the 125 states parties to request their participation in the general debate of the Assembly, and I'm extremely grateful to record the participation of, I believe it's 25 ministers and deputy and vice ministers today. Together, further to the guidelines for enhancing the security of participants in the regular sessions of the Assembly of States Parties and its side events, which were adopted by the Bureau on 4th October 23, I continue to consult with states parties, the court and civil society regarding possible further measures which could be undertaken. I encourage a continued dialogue to further reinforce the guidelines going forward. Universality is essential for the effectiveness and legitimacy of the Rome Statute system. Striving for universality is a shared responsibility of both the Court and the Assembly, and it is crucial for upholding international justice and accountability. In light of this, the Presidency of the Assembly, in consultation with the Court, has made continued efforts to enhance universality with the assistance of the ad hoc country focal points on universality, the Netherlands and the Republic of Korea, as well as civil society, in particular parliamentaries for global action. Our sincere gratitude goes to all involved in this important endeavour, as their dedication and commitment are vital to ensuring that the Rome Statute system remains robust, inclusive and impactful on the global stage. I wish to take this opportunity to welcome the newest member of the Rome Statute system, Ukraine. The Rome Statute entered into force for Ukraine on the 1st of January 2025, representing a significant development towards universality. On behalf of the Assembly of the State Parties, I would like to congratulate Ukraine on this important step. Pour conclure ce rapport oral du Bureau, je tiens à exprimer une fois encore ma profonde gratitude au vice-président de l'Assemblée, aux membres du Bureau, aux facilitateurs et aux points focaux, ainsi qu'à l'ensemble de cette partie. J'adresse également ma profonde reconnaissance à nos partenaires inestimables de la société civile et au personnel dévoué de la Cour. Leur efforts constants, leur appui et leur engagement sont essentiels à la réussite de nos objectifs communs. L'année 2025 a été particulièrement difficile pour la Cour et le système du statut de Rome. Il est essentiel que nous demeurions solidaires de la Cour et de ses fonctionnaires. L'Assemblée de cette partie poursuit son action en faveur de la Cour et de la défense des principes et des valeurs consacrées par le statut de Rome, conscient que la justice internationale n'est pas seulement possible, elle est impérative. May I take it that it is the wish of the Assembly to take note of the oral report of the Bureau? I see no objections. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 8. Distinguished delegates, we turn now to Agenda Item 9, Report of the Activities of the Court. The report is contained in document ICC-ASP24/11. We are honoured to have the Presidency of the Court, a Deputy Prosecutor and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. I will invite the President of the Court, Judge Tomoko Akane, and Deputy Prosecutor Monsieur Mam Mandiamniang, to address this plenary today. The Registrar, Mr. Osvaldo Zavala-Hilaire, will deliver remarks to the Assembly when we take up Agenda Item 12, consideration and adoption of the budget for the 24th financial year. I shall first give the floor to the President of the Court, Judge Tomoko Akane.
Madam President of the Assembly, esteemed delegates, civil society representatives, ladies and gentlemen. I'm honored to address this 24th session of the Assembly of State Parties on behalf also of First Vice President Aitara, Second Vice President Lapine Gansu, and the whole court. When I reported on the activities on the International Criminal Court before the United Nations General Assembly on 11 November, the President of this General Assembly, Ms. Annalena Baerbock, stated that the court does not, on its own behalf, but in defense of the principles of the United Nations Charter to protect us all from the gravest crimes, State parties, therefore, cannot remain silent. Indifference will lead to a world in which might makes right. We are profoundly grateful to those state parties which have been actively supporting the court in the last months, openly or discreetly, lending political backing as well as material aid through their companies which make the operations of the court possible in the current circumstances. This presidency has sought to maintain a dialogue with as many states as possible and has traveled to capitals from all regional groups during the past year. We are particularly grateful to those states that have welcomed us and enriched our work with their views. We will continue our diplomatic outreach in the months to come. The values underlying the Rome Statute, as articulated the preamble, are common to the entire humanity. Committing to universality is therefore vital to reaffirm those values and thus to strengthen the court's legitimacy. The court will continue its effort to increase the number of state parties and appreciates the commitment of our civil society partners in raising awareness and promoting universal ratification. I believe the issue of regional representation is a key in this respect, and I encourage this assembly to continue actively discussing this matter. The court, for its part, will continue with regional seminars and other universality initiatives. Madam President, last year I have recalled before its distinguished assembly the looming dangers for this noble institution: international law, international justice, and eventually humanity. I have also pledged on behalf of all women and men who work for the court that we would have never given up to coercive measures, threats, sabotage, or outrage. Both the prediction and the proposition came true. Today, 9 elected officials, including 6 judges, have been designated for sanctions by the United States, alongside with terrorists and drug traffickers. Their personal and family lives are being unsettled, and their ability to conduct financial transactions disrupted, also in the territories of state parties, including in Europe. 9 elected officials, including 1/3 of the judges, as well as the totality of the ICC presidency, are subject to arrest warrant issued by the Russian Federation. Just a few days ago, it was reported that the investigative committee completed its investigation and placed these elected officials on the wanted list. As far as we know, these officials have been indicted and arrested in absentia, and hearings are being held in their absence. This will have an obvious impact on their personal security. These coercive measures plainly aim at undermining the existence and the reputation of the court and integrity of its judicial proceedings, and the safety and serenity of the officials. The response of the court has been absolutely unambiguous. Our independence and impartiality are our polar stars and remain unaffected. Our loyalties are only with the Rome Statute and international law. The court has taken several measures to mitigate the impact of these coercive measures and strengthen our resilience. Most of these measures remain confidential to ensure their effectiveness, but I would again like to thank states that are working with us to find solutions. Let me be explicit. We never accept any kind of pressure from anyone on issues of interpretation of the statutory framework and adjudication of cases. Any dispute concerning the judicial functions of the court shall be settled by the decision of the court, reads Article 119 of the Rome Statute. We encourage states parties to resort to timely consultations under the statute if they identify problems in the execution of requests for cooperation. The court also recalls that the Rome Statute provides for legal avenues for states to pursue the value underlying the Charter of the United Nations without infringing on the independence and impartiality of the court. Madam President, the achievements of the court this year speak for us unequivocally. In the face of the unprecedented levels of workload and amidst the attacks against it, the court is acting expeditiously and effectively in all stages of proceedings, investigations, pretrial, trial, appeals, and reparations. I pay tribute to our staff in chambers, the OTP, and the registry for these results. Everyone is acting with dignity, resilience, professionalism, and abnegation. We are all bound together by the awareness of the gravity of the moment and the firm determination to protect at any cost the values on which we have solemnly sworn. We consider ourselves accountable to any and all victims, particularly children and women. We are committed to our missions and thus the duties enshrined in the Rome Statute. I have provided the full overview of the court's activities to the Assembly in writing. I am only mentioning some key developments. The pretrial division has issued numerous arrest warrants of great importance and complexity, emanating from several situations across continents. Most of the arrest warrants remain under seal until the judges decide differently. In any criminal court, confidentiality is key for orderly conduct of the proceedings. The seriousness of the judicial function, and the appearance of independence and impartiality. A new regulation recently adopted by the plenary of the judges, which standardizes the existing practice of pretrial chambers, provides that all applications for arrest warrants or summons to appear must be classified as secret or under seal and cannot be reviewed. It is for judges to decide on a case-by-case basis whether to make the issuance of arrest warrants public, including in order to interrupt criminal conduct, deter other crimes, or maximize opportunities for arrest. In the Sudan-Darfur situation, which was referred to the court by the United Nations Security Council, the chamber has convicted Mr. Abdurrahman, a leader of militia, for 27 counts of crime against humanity and war crimes. This case concerned crimes committed in an armed conflict in 2003 to 2004, which have taken the lives of and forced the freeing of hundreds of thousands of civilians, including children. many of those who are displaced were unable to return. 1,600 victims have participated in the trial. We trust this judgment will light a little spark of hope for the many who are suffering in the ongoing conflict at this very moment. The case against Mr. Joseph Kony in the Uganda situation has marked the first instance in absentia confirmation proceedings at the court. In the situation in the Philippines, the surrender of Mr. Rodrigo Duterte was the first from the Asia-Pacific region. A new surrender in the situation in Libya is imminent, as if realized, a new confirmation proceeding will commence. The court acknowledges with gratitude the cooperation in the arrest and surrender of suspects of the concerned states. When states cooperate with the court, regardless of whether they are parties to the statute, they nurture justice, the rule of law, and the values that bind humanity together. Madam President, the court is committed to improve its workplace culture, and the leadership is applying zero-tolerance policy against harassment, including sexual harassment, as well as discrimination and abuse of authority. The presidency and the plenary of the judges, as well as the court as a whole, take this issue with absolute seriousness. Where we had authority in line with the legal framework, we have held accountable those who needed to be, including an elected official this year, in order to protect affected staff members swiftly, impartially, and in compliance with due process. The court is also working to improve its internal systems and processes, as well as on the Charter of Ethics. We have also released court-wide core values. The court also appreciates the leadership of the presidency of the ASP with the state parties in line with their authority on the matter before it. Everyone must be accountable, elected officials and staff. This, I strongly believe, is essential to protect the court's resilience and credibility. Staff also deserve that any misconduct or unsatisfactory conduct is dealt with appropriately in line with the applicable framework. I would like to also encourage staff to continue focusing on their core duties with serenity, with trust in the applicable processes. Madam President, in my office at the court, I have a piece of calligraphy with the words of Lao Tzu, a Chinese philosopher from the 6th century BC, which roughly translates to, "A grand image does not have form." It means that grand things do not have a shape which our eyes are able to see. We humans tend to focus on things that are immediately before us, and in doing so, we neglect looking at the bigger picture or matters that are of fundamental significance. I respectfully invite all of you to look at the grand image that underpins our work, the cause of humanity and justice, which has no boundaries. They are universal. Now more than ever, we must turn our eyes to the unseeable suffering of countless innocent civilians. We must redouble efforts to defend human dignity. I call on states, including states not parties to the statute, and all persons to stand united with a code in defense of humanity. Organizations of civil society have accompanied the code hand in hand since the very beginning of the 50-year-long process that has led to 17th July 1998 in Rome. We need you more than ever. Your thirst for justice is the thirst of humanity. We know that the current circumstances are also affecting you, but we beg you to continue working for our cause. Better times will come. To borrow the words of Nelson Mandela, a winner is a dreamer who never gives up. We must remember that we are all working for a cause, a grand, albeit unsignable cause. We must continue to work for this cause, to provide hope for humanity, and to realize a more just world that is free from atrocities, where future generations peacefully coexist. Thank you very much.
I thank President Akana for her powerful and timely statement. I now invite Deputy Prosecutor Mam Mandaye Nyang to address the Assembly.
Madame la Présidente de l'Assemblée, Madame la Présidente de la Cour, honorable juge de la Cour, Monsieur le greffier, Excellences, distingués délégués, chers collègues, Mesdames et Messieurs, j'ai l'honneur de prendre la parole aujourd'hui après Madame la Présidente de la Cour, en ma qualité de procureur adjoint assurant l'intérim du procureur, donc à mon nom et au nom également de Madame la procureure adjointe Nazar Chamin Khan. Sans aucun doute, cette année a été marquée par des défis immenses, mais elle nous a aussi, j'en suis profondément convaincu, donné de nombreuses raisons de croire que nous pouvons encore ensemble faire triompher la promesse fondamentale du statut de Rome. Au cours de cette année, nous avons fait face à deux dynamiques opposées. D'un côté, la confiance et l'espoir ravivé des victimes. De l'autre, des acteurs puissants qui s'emploient à saper notre travail et à imposer l'impunité. Nous ne devons pas l'accepter. Je voudrais commencer par un message d'espoir, ainsi qu'un rappel solennel de notre dessein commun, en m'appuyant sur les paroles poignantes et courageuses prononcées par un survivant du Darfour. Et je le cite. Voici ce qu'il dit. Je dépose devant vous ma voix, mais aussi celle de l'ensemble des réfugiés du Darfour, dispersés à travers le monde. Je viens vous dire que nous aspirons à la paix. Nous exigeons la justice. Nous voulons que tous ceux qui ont fait de nos vies un enchaînement d'humiliation, de souffrance et d'épuisement répondent de leurs actes. Nous voulons que ceux qui ont brisé nos existences et compromis l'avenir de nos enfants soient enfin jugés. Assez, il est temps. Voilà ce que cette victime nous dit. Et ces mots projettent la quintessence de ce que cette Cour peut offrir à celles et ceux qui n'ont aucune autre voie vers la justice. Ces mots traduisent les récits et les émotions de nombreuses victimes et survivants avec qui nous dialoguons. Des victimes dont la confiance demeure intacte, même lorsque leur univers semble s'effondrer. Ils rendent hommage aux témoins qui, souvent, au prix de sacrifices immenses, ont choisi la vérité plutôt que le silence, la justice plutôt que la peur. Leur courage est une lumière dans l'obscurité, une force qui inspire et qui élève. Ils sont la raison d'être des avocats, des juristes et des défenseurs des droits humains qui, aux quatre coins du monde, poursuivent inlassablement la cause de la justice, parfois sous la menace, souvent sans reconnaissance, mais toujours avec une conviction inébranlable et une foi profonde en l'idéal de justice et du droit. Ces mots nous rappellent que cette Cour n'est pas une institution abstraite. Elle peut être une bouée de sauvetage. Elle porte la promesse que même dans les heures les plus sombres, les droits des individus ont une valeur. Madame la Présidente, Excellences, Mesdames et Messieurs, dans le monde qui s'offre aujourd'hui à nous, meurtri par les conflits, gangrené par la désinformation et fragilisé par l'impunité, la Cour pénale internationale s'affirme avec une pertinence renouvelée. De l'Ukraine au Darfour, de la Palestine au Venezuela, de la République démocratique du Congo aux Philippines, jusqu'en Libye, les voix se sont multipliées et les appels se sont intensifiés. Notre bureau a reçu un afflux sans précédent d'appels à l'aide. Par ces communications, un message clair résonne. Ces communautés nous interpellent, nous regardent et attendent de nous reconnaissance et responsabilité. Elles réclament que la justice ne soit pas un idéal lointain, mais une réalité tangible. Nous sommes pleinement conscients que ces attentes sont largement partagées par nombre d'entre vous présents ici. États partis, organisations de la société civile et partenaires, vous qui, avec force et constance, avez exhorté le Bureau à agir, à mener des enquêtes et à rendre justice, y compris dans les contextes les plus éprouvants. Bien que cette intensification de l'engagement soit le reflet d'un paysage sombre, marqué par des violences accrues et des souffrances profondes, elle véhicule également un message d'espoir. la reconnaissance de la Cour pénale internationale comme une institution digne de confiance, une institution vers laquelle elles peuvent se tourner. Mais comme pour faire contraste à ces sollicitations, nous avons dû faire face à des pressions politiques visant à compromettre l'indépendance de notre action. Alors que nous entamons une réflexion collective au cours de la semaine, il importe de faire preuve de franchise et de reconnaître que les sanctions qui nous sont imposées et dont Madame la Présidente a longuement parlé, et ces sanctions ont entraîné des répercussions négatives. Elles ont suscité des inquiétudes et engendré des incertitudes. Elles affectent drastiquement la vie de ceux qui sont directement affectés. Ces sanctions s'étendent désormais à certains de nos partenaires de la société civile. Et je tiens à réaffirmer notre pleine solidarité à ces organisations de la société civile. C'est un rappel saisissant que la défense de la justice exige souvent des sacrifices personnels, mais c'est aussi un appel impérieux à la persévérance, car si ceux qui poursuivent la justice deviennent des cibles, ce sont les victimes elles-mêmes qui sont menacées. Et avec elles, l'idée même d'une responsabilité universelle. Je tiens à être clair. Ces pressions, qu'elles soient institutionnelles ou personnelles, ont renforcé plutôt qu'affaibli notre conviction dans la noble mission de cette Cour. C'est un moment difficile, certes, mais c'est une épreuve pour laquelle nous nous sommes préparés et que nous affronterons unis et avec détermination. Et j'ai pu personnellement observer le courage et le professionnalisme de mes collègues qui poursuivent leur mission sans désemparer. J'ai également perçu dans chaque déplacement, dans chaque rencontre avec nos partenaires, cette attente parfois silencieuse mais inébranlable, nous ne devons pas fléchir. Car la justice, fût-elle contestée, doit demeurer ferme et inaltérable. Elle est le socle de notre engagement, la boussole de notre action et la promesse que nous faisons au monde, celle de ne jamais céder face à l'épreuve, mais de tenir avec constance et honneur pour que le droit triomphe. Madam President, Excellencies, ladies and gentlemen, in that spirit of common purpose and drawing on the continued hope shown by so many of you this year, the office has ensured that 2025 was a year of real progress, a year that demonstrates what determined, principled action together with our partners can achieve. Building on the unprecedented engagement we have received from affected communities, a record number of arrest warrants have been issued or executed. These have included an essential recognition of the nightmare faced by women and girls in Afghanistan every day. and across the situations we address, we are delivering concrete progress through focused and effective investigations, drawing on our cooperation with you. Based on this action, we have seen landmark arrests in this year, including that of Rodrigo Duterte, former president of the Philippines, now before the courts on charge of crimes against humanity, and Khaled Ali El-Ishri, arrested in Germany for crimes in Libya's detention facilities. And I wish, after Madam President, to express our thanks to our registry, first and foremost, our registry colleagues in particular, for the strengthened coordination that has led to such results, as well as to German authorities for their diligent and ongoing efforts in implementing this warrant of arrest. In the courtroom, we have also reached important milestones. The conviction of Ali Abdurrahman marked a turning point as the first conviction in relation to crimes committed in Darfur, the first conviction pursuant to a referral made by the United Nations Security Council, and the first at the ICC for gender persecutions. This is a limited, still insufficient, but essential moment of recognition for the people of Darfur. Most importantly, it sends a clear message. The message that those on the ground in Darfur who seek to inflict suffering should know that the sense of impunity they feel at this moment will not last forever. The office is working intensively on recent events in El Geneina, Al Fasher, and other locations to ensure that perpetrators are held to account. Deputy Prosecutor Nazar Khan and I are personally committed, in particular, to ensuring that the sexual violence and broader gender crimes being committed in Darfur are thoroughly investigated. Other landmarks have also been achieved. Last month, the ICC chamber confirmed all 39 charges brought by the office against the Lord Resistance Army commander, Joseph Kony, following the first hearing in absentia by this court. That was in September. And earlier this year, the conviction and sentence of Alfred Yakatom and Patrice Edouard Ngaisona in the Central African Republic for war crimes and crimes against humanity here again reaffirm that justice, that may take time, but it does come. Each of these achievements attained through our cooperation with all partners demonstrates that despite the headwinds we face, this court is working. These outcomes also demonstrate the living relevance of the Rome Statute. They show how our renewed policy framework on gender persecution, gender-based crimes, crimes against and involving children, and slavery crimes, all of those policies, so this framework is producing now tangible results in court. With the launch of our policies on environmental damage and cyber-enabled crimes under the Rome Statute at this Assembly, the Office now concludes a significant phase of thematic policy development, one that strengthens the Rome Statute ability to address the evolving threats of our time and allows us to partner in ever-evolving ways with organizations at national and regional level. We are grateful to state parties who have contributed to the realization of these policies and underlined their willingness to support next steps in their implementations. We are also seeing positive developments in widening circles of cooperation, even in places where the doors once seemed closed. There have been signs of openness and constructive engagement from Sudan and Libya, both states not party to the Rome Statute and situations referred to by the UN Security Council. In both contexts, channels of communications and cooperation that had long been constrained are beginning to re-emerge. These developments, while fragile, mark a positive shift and an important opportunity to establish partnerships and strengthen accountability efforts in two situations that have tested the resolve of the international community for over a decade. Similar momentum has also been seen in relation to other states not party to the Rome Statute, who have increasingly engaged with the office to enhance their knowledge and understand how we can work together. There is a real, if nascent, opportunity in this moment to widen our engagement to strengthen universality. This year, the office has also strengthened its approach to positive complementarity, recognizing that sustainable justice depends on national ownership, and emphasizing that the office wishes to serve as a partner with all states in pursuit of accountability. This renewed approach has allowed us to deepen our engagement in relation to domestic processes in Colombia, the Central African Republic, the DRC, Ukraine, and Guinea, reinforcing judicial capacity, exchanging knowledge, and empowering national jurisdiction to act. The strengthening of this partnership and those in other situations will remain a key priority in the coming year, in line with our policy on complementarity and cooperation. In Venezuela, however, following sustained engagement, we have determined that real progress on complementarity has still been a challenge. Accordingly, and mindful of the need to effectively manage our limited resources, we have decided to close our in-country office in Caracas. Our investigation in this situation remains focused and active, based on the work of our dedicated unified team, together with our partners and guided as always by the evidence and the law. In the office workplace, let me just say a few words in that office workplace. Within our own institution also, we have recognized the need to place further emphasis on accountability and well-being. The past year has brought legitimate scrutiny to our internal culture. The office has taken this concern to heart we have sought to ensure a calm space for our dedicated staff, while the independent process established by the Assembly being conducted by the United Nations Office of Internal Oversight Services, while this process has been ongoing. The resolution of this issue remains a matter of urgency and priority, as we as Deputy Prosecutor, we remain personally committed to fostering a workplace anchored in respect, dignity, equality, and trust. Those values that must underpin any institution that seeks to deliver justice for others. Creating a safe, respectful, and inclusive workplace is not just a strategic priority. It is a deep commitment shared across all levels of this office. Listening to staff, legitimate concern, learning from feedback, and embracing bottom-up proposals will be key to the journey ahead. Madame la Présidente, distingués délégués, Mesdames et Messieurs, à l'aube d'une nouvelle phase institutionnelle sous l'égide du plan stratégique de la CPI pour la période 2026-2029, l'ensemble des organes de la Cour ainsi que le Fonds au profit des victimes se trouvent unis sous le principe d'une seule Cour. Cet alignement renforce notre capacité collective à agir avec cohérence, rapidité et impact. Il est, sous certains aspects, le fruit de l'environnement contraignant auquel nous faisons face. Soumis à des pressions externes, nous avons su renforcer notre coordination et notre unité. Nous aurons besoin de ce sens commun du but partagé par chacun d'entre nous ici aujourd'hui pour affronter les défis qui se profilent à l'horizon. Bien que les avancées de notre travail soient indéniables et que l'exigence d'action n'ait jamais été aussi pressante, nous devons néanmoins reconnaître qu'au sein de certains cercles de la communauté internationale s'expriment des signes d'hésitation, voire de lassitude, révélant un affaiblissement préoccupant du consensus, pourtant établi de longue date, autour du rôle fondamental de l'état de droit dans l'ordre international. Nous devons affronter cette tendance ouvertement, avec franchise et détermination. Et nous devons l'affronter ensemble. Nous pouvons y parvenir en démontrant, par la force de nos actes, que l'action de la Cour pénale internationale revêt une valeur non seulement pour les victimes des crimes, mais également pour l'ensemble de la communauté internationale. Face aux tentatives visant à fragiliser notre action, nous devons affirmer avec clarté que les obligations découlant du statut de Rome demeurent pleinement applicables. J'en appelle à un soutien renouvelé et concret pour faciliter les missions, exécuter les mandats d'arrêt, partager les informations et protéger les témoins. Il ne s'agit pas là d'actes de générosité. Ce sont des obligations juridiques essentielles à la crédibilité de ce système collectif de justice dont les bénéfices ultimes nous concernent tous. Face aux forces de fragmentation, la présence aujourd'hui ici, à La Haye, de tous ces délégués, de ce grand nombre d'États, partis, d'observateurs, d'organisations de la société civile et de représentants des victimes constitue une déclaration de foi. Foi en la justice pénale internationale et en la pertinence durable du système institué par le statut de Rome. La Cour pénale internationale n'a jamais été conçue pour accomplir une tâche aisée. Elle a été créée pour répondre à une nécessité impérieuse, rendre justice face aux crimes les plus graves, ce qui heurte la conscience de l'humanité. Et pour ceux d'entre nous qui la servent, cette mission revêt également une dimension personnelle, un engagement visant à faire en sorte que le droit demeure un refuge pour ceux qui n'ont nulle part ailleurs où se trouver. Unissons-nous donc, État, société civile, victimes et cours, avec une conviction renouvelée. La responsabilité n'est pas un luxe dans la quête de la paix, elle en constitue le fondement même. Comme nous l'a rappelé avec force le survivant du Darfour que j'ai cité, l'édifice de notre action commune repose sur l'impérieuse exigence de justice portée par les victimes de crimes du statut de Rome. Car, fussent-elles les plus obscures, les pages de notre histoire collective ne se lisent point à travers le prisme du désespoir, mais bien à celui de la résilience, de la fraternité et, in fine, de la réaffirmation même de notre humanité partagée. Face aux menaces et à la désinformation, une certitude demeure. Nous resterons fermement engagés et résolus à défendre cette vérité fondamentale qui reconnaît que toutes les vies ont une valeur égale en droit international. Et je vous remercie de votre attention.
I thank Deputy Prosecutor Mammani Yang for his informative and relevant statement. I propose that the Assembly take note of the report of the International Criminal Court contained in document ICC-ASP24/11. I see no objection. It is so decided. I would like to take this opportunity to express my gratitude to the Court for the support it has provided to various mandates and initiatives of the Assembly, to the Bureau and its working groups, and to me personally. The Assembly has thus concluded its consideration of Agenda Item 9. Distinguished delegates, let us now turn our attention to Agenda Item 10, report of the Board of Directors of the Trust Fund for Victims. The report on the activities and projects of the board for the period of 1st July 24 to 30th June 25 is contained in document ICC-ASP/24/14. And I now have the honor to give the floor to Mr. Andres Parmas, Chair of the Board of Directors of the Trust Fund for Victims.
Dear Madam President, Your Excellencies, court officials and delegates, members of civil society organizations, members of communities affected by the crimes under the jurisdiction of this court. It is an honor to address you. We are gathered at a critical moment when, on the one hand, children, women and men continue to be victims of massive and unimaginable atrocities, and on the other, the court and the entire foundation of international criminal justice are facing unprecedented attacks and existential threats. At this time, we must stand together and remember why we are all here. The ICC was created to bring justice and to redress the harm that the most serious crimes cause on individuals, on communities, and on the whole nations. In this endeavor, the reparative work of the ICC through the Trust Fund for Victims ensures justice to victims. The judicial proceedings of the court have advanced and they have expanded, and thus the work of the Trust Fund needs to be understood by our critics and our supporters alike as being at the heart of the aspirations of the Rome Statute. For too long, efforts of redress to victims have been treated as an add-on to accountability, almost as an afterthought in our words and deeds about the ICC internationally and domestically. Programs for the benefit of victims have received the much appreciated voluntary financial support from numerous states parties. But still, the number of contributing countries and the volume of this support is too little to do justice to the lofty ambitions of those who have adhered to the aspirations of the Rome Statute. Your government established this court because nations learned the hard way that the lack of accountability threatens peace and it threatens security, and that lack of redress and reparation repeat cycles of violence. The Board of Directors has reported to the Assembly what redress has meant in practice. Nearly 78,000 individuals have benefited in the past 5 years. Every figure in our reports, they represent a person, a life, a former child soldier seeking to rebuild a broken childhood, a survivor of sexual violence reclaiming their sense of safety and dignity, a community struggling to preserve its culture and way of living after devastation, and many others. Nearly 3/4 of participants in our programs that are presented in the report refer to women and girls. These women are not merely beneficiaries. They are survivors. They are caregivers and agents of resilience, holding families and communities together despite immense trauma. The Rome Statute system exists for them. So when the court is supported and when victims experience reparative justice, you are enabling not only the upholding of norms, but also healing. You are enabling hope that devastation may have an end. Together, we are building a narrative of hope and our common future. In approving the budget for the court to do its work, in protecting the court from threats, and in providing necessary contributions to the Trust Fund for Victims, you are declaring to your own nations and to the world that norms and people matter, that security matters, and that peace matters. The court and the Trust Fund have done the work. With successful convictions of the most responsible perpetrators of mass crimes, the continuous delivery of reparations and programs of assistance, with economic prudency and unstoppable determination for business continuity in the face of serious threats. This work resulted, as is visible in the report of the Trust Fund for the Victims presented to the Assembly, that in 2024, with your support, we reached the highest level of contributions, nearly 6 million euros, a historical high. However, I regret to report that the outlook for 2026 is dire. The Trust Fund for Victims anticipates a sharp decrease in income this year, possibly near to merely 25% of what was received last year. Despite these limitations, through radical and difficult prioritization decisions, the Board of Directors is pleased to announce that the Trust Fund for the Victims will complete the second reparations program in the Almaty case and will continue delivering reparations in the Lubanga and Ntaganda cases. Also, the Trust Fund has received the first pledge for resources to launch the reparations program in the Ongwen case. This first pledge from the ODA eligible funding from Finland, together with the allocations that the board made from contributions in 2024, will shortly enable the announcement of the first complement to the Ongwen reparation order, and to launch the initial phase of the program, even if only modestly. The Board of Directors has reported to the Assembly on the substantive measures to enhance the visibility of the Trust Fund and of the fund mobilization strategy of the fund, which was consulted at the Hague Working Group level throughout this year in a process nourished by the active engagement of numerous state parties under the facilitation and leadership of His Excellency Vusi Madonsela, Ambassador of South Africa to the Netherlands. Looking ahead, the strategic plan of the ICC for the 2026-2029 period will contribute to the reinforcing the work of the Court and the Trust Fund on Victims by delivering prompt and meaningful measures of redress, in line with the vanguard reparation principles issued by the judges according to the Rome Statute Article 75. In closing, the Board of Directors wishes to recognize the work of the ICC Presidency, the judges, the deputy prosecutors and their office, as well as, very importantly, of the essential support the Trust Fund for Victims has received from the registry. The Board of Directors acknowledges the trust that affected communities have put in the Court and the Trust Fund for the Victims as they are engaging in the programs. The Trust Fund is both humbled and driven by our service to them. Dear Excellencies, justice, very much like history, is made by the acts of individuals. This includes activists, human rights defenders, academia, and the staff of this Court. Centrally, it relies on you, delegates from state parties, who have the power to shape through this Assembly a pathway towards justice and redress for the benefit of all humanity. I thank you very much for your attention.
I thank Mr. Parmas for his statement, and on behalf of the Assembly, I ask that he convey to the distinguished members of the Board the appreciation of the Assembly for their tireless efforts and commitment to provide effective remedy to victims. I propose that the Assembly take note of the report of the Board of Directors of the Trust Fund for Victims contained in document ICC-ASP24/14. I see no objection. It is so decided. We have thus concluded our consideration of Agenda Item 10. The Assembly will now begin its consideration of Agenda Item 5. In accordance with Rule 25 of the Rules of Procedure, a Credentials Committee consisting of representatives of 9 states parties shall be appointed at the beginning of each session on the proposal of the President. After broad consultations with states parties, I propose that the Credentials Committee consists of the following states: Costa Rica, Czech Republic, France, Germany, Norway, Panama, Slovenia, South Africa, and Uganda. May I take it that the Assembly agrees to proceed accordingly? It is so decided. I wish to remind representatives that pursuant to Rule 25 of the Rules of Procedure, credentials shall be submitted to the Secretariat, if possible not later than 24 hours after the opening of the session. Credentials shall be issued by the head of state or government or by the Minister of Foreign Affairs or by a person authorized by either of them. Before we move to the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Ms. Sakura Ozaki of Japan as rapporteur for the 24th session. Does the Assembly agree to appoint Ms. Sakura Ozaki as rapporteur for the 24th session? I see no objection. It is so decided. I congratulate Ms. Ozaki on her appointment and thank her for her willingness to take up this responsibility on behalf of the Assembly. Distinguished delegates, we shall now turn to agenda item 6, Organization of Work. The Bureau has considered the program of work, which is reflected in the ASP journal dated 30th of November 25. The Bureau proposes that this program form the basis of our work for this session. I trust that you will all understand that the program of work may be subject to modification depending on the progress attained on the different items. I would ask each representative to ensure that she and he arrives on time to the meetings in order for the Assembly to complete its consideration of all items on its agenda for the 24th session. May I take it that the Assembly decides to adopt the program of work reflected in the ASP journal dated 30th November 25? I see no objection. It is so decided. As proposed by the Bureau, the Assembly will meet in plenary session and will hold informal consultations on some key issues on which decisions must be taken. At its 3rd December 25 meeting, the Bureau recommended that the following representatives be appointed as coordinators for the 24th session. For the working group on the program budget is Ambassador Jorge Carvajal San Martin from Chile. For the informal consultations on the omnibus resolution, Ms. Beatrice Maillet of Canada. May I take it that the Assembly wishes to proceed on this basis? I see no objection. It is so decided. I congratulate Ambassador Jorge Carvajal San Martin and Ms. Beatrice Maillet and wish them every success as they carry out their responsibilities. I assure them that they can rely on the Bureau to provide any guidance that may be necessary. The Assembly will now turn to agenda item 4, States in Arrears. According to Article 112, paragraph 8 of the Rome Statute, a state party which is in arrears in the payment of its financial contributions towards the cost of the court shall have no vote in the Assembly and the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from it for the preceding 2 full years. The Assembly may nevertheless permit such a state party to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 21st October 25 to all concerned states via their United Nations missions as well as their embassies in The Hague and Brussels, informing them that they were in arrears and stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute. In accordance with information provided by the court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 12 states parties. I have been informed that one state party, the Central African Republic, has paid its assessed contribution so that the provisions of Article 112, paragraph 8 are no longer applicable to this state. I thank the Central African Republic for paying its contribution to the budget of the court. I wish to note that the Bureau, having received a request for waiver from the loss of voting rights for the 24th session of the Assembly from the Bolivarian Republic of Venezuela, decided to recommend that the Assembly grant this request for a waiver from the loss of voting rights at the 24th session. At the same time, as mentioned in my oral report, the Hague Working Group has discussed the issue of developing criteria for the grant of waivers in the budget management oversight facilitation during the intersessional period. A draft resolution was approved by states parties on the procedure and criteria for the waiver of the loss of rights. If this resolution is adopted at the current session, the procedure to be agreed for criteria for the grant of waivers for the loss of voting rights will apply to all future situations of voting by the Assembly. Does the Assembly agree to grant the request for waiver of the loss of voting rights which it has received? Thank you. It is so decided. We will proceed accordingly. We have 3 countries requesting the floor after taking this decision, and we will give first floor to Argentina.
Señora Presidenta, gracias por darme la palabra. Permítame desearle una sesión fructífera y cuente con el apoyo de mi delegación. La Argentina desea tomar la palabra para disociarse del consenso, dado que es necesario reiterar lo que ya señaló en el 23 periodo de sesiones ordinarias de esta Asamblea en relación con la situación de Venezuela. La situación en Venezuela, que se ha deteriorado aún más tras las fraudulentas elecciones de julio de 2024, exige una atención inmediata. Notamos que desde que la Oficina del Fiscal anunciara en noviembre de 2021 la conclusión del examen preliminar sobre la situación en Venezuela, ha habido pocos avances. Las detenciones arbitrarias, los tratos inhumanos y otros crímenes contra la humanidad que perpetra el régimen venezolano requieren investigaciones rigurosas pero expeditivas, incluyendo el dictado de órdenes de arresto contra sus principales responsables. La decisión de la Argentina de no bloquear el consenso en torno a esta cuestión, lejos de entenderse como un gesto hacia Venezuela, es en realidad una muestra del compromiso de la República Argentina con la Corte Penal Internacional y del valor que le otorga a la labor de esta Asamblea, incluyendo no precluir las negociaciones en curso para establecer un procedimiento general relativo a la situación de Estados parte en situación de atrasos en los pagos. Permítame enfatizar que Argentina no se siente ni puede ser considerada parte de la decisión que se adopte, disociándose de la misma, y le pido que quede registro de ello en los informes y actas de esta Asamblea. Muchas gracias.
I thank the representative of Argentina and give floor to Canada.
Thank you, Madam President. The Budget Management Oversight Facilitation has given us a constructive space to engage on the issue of waivers under Article 112, Paragraph 8 of the Rome Statute, an area on which Canada has worked collaboratively with states parties over several years. We warmly congratulate Ambassador Tisalu for his skillful leadership of these discussions this year. We welcome the newly found consensus to clarify the framework and criteria to assess waiver requests when a state's party's inability to pay arises from conditions beyond its control. This is an important development. Such clarity will strengthen confidence in the integrity and fairness of the process. States parties must ensure that the court receives its full budget allocation. This begins with full and timely payment of assessed contributions. This is essential to safeguard the court's ability to carry out its mandate effectively and to improve its resilience, which are front of mind as we reflect over the next 2 days on how states parties can take concrete measures to support the court at this time. In this regard, we are encouraged that the court received over 90% of its assessed contributions this year, a testament to the collective commitment of states parties. Canada remains committed to working constructively with all states parties to uphold the financial sustainability and independence of the court. Thank you.
I thank the representative of Canada and give floor to Japan.
Thank you, Madam President. Japan welcomes the consensus achieved on the procedure and criteria on the waiver of the loss of voting right after months of consultations held in the BMO facilitation under the leadership of Ambassador T. Salu of Estonia. Japan sincerely looks forward to the implementation of a structured, transparent, and objective waiver procedure going forward. Thank you very much.
I thank the statement by Representative of Japan and give floor to Venezuela.
Gracias, señora presidenta. Al ser la primera vez que tomo la palabra, me permito saludarle a usted, desearle éxito en las deliberaciones y saludar también al resto de la sala. Venezuela quiere agradecer nuevamente la solidaridad de todos los miembros de la Asamblea por haber otorgado este derecho al voto, el mantenimiento del derecho al voto. Venezuela, desafortunadamente, por las razones ampliamente conocidas, no está en capacidad de honrar sus compromisos. Sin embargo, confía que una vez proceda el levantamiento de las ilegales medidas coercitivas unilaterales, estemos en capacidad de poder honrar la deuda que mantenemos con esta honorable institución. El compromiso de Venezuela ha quedado notablemente manifestado una vez más con su participación activa en los trabajos del EBMO y saludamos que hasta ahora haya podido conocerse una flexibilidad suficiente que permita definir criterios que en el futuro también nos ayuden a evitar esta situación. Conocemos de la particular sensibilidad en el caso de las medidas coercitivas unilaterales, siendo que la Corte hoy, desafortunadamente, es también víctima de este tipo de prácticas que atentan contra el derecho internacional. Luego de esta intervención positiva, me veo en la obligación también de responder al gobierno de Javier Milei, que desafortunadamente y de forma altisonante pretende politizar esta conferencia, señalando no solo de manera inoportuna elementos politizados en contra de la legitimidad de mi gobierno, pero además erigiéndose en un falso defensor de derechos humanos. Si el gobierno de Javier Milei quiere hablar de régimen, yo creo que tiene que hablar del régimen efectivamente y ocuparse del régimen de los derechos humanos y de su compromiso internacional. Desde junio de este año hemos notado con vergüenza cómo Argentina ha votado en 5 resoluciones de Naciones Unidas, todas ligadas al tema de derechos humanos, siendo la última de ellas la tomada el 20 de noviembre de 2025 alrededor de la resolución sobre la tortura y otros tratos y penas crueles, inhumanos y degradantes en el marco de la 51ª sesión plenaria de la Tercera Comisión de la Asamblea General de Naciones Unidas, en la cual Argentina votó en contra de manera vergonzosa y contra los distintos compromisos que la región ha alcanzado en esa materia. De tal manera que invitamos tanto a Argentina como al resto de los estados a concentrarnos positivamente en los trabajos de esta Corte para garantizar que podamos avanzar constructivamente y con un espíritu de solidaridad en los temas que nos resultan comunes. Muchas gracias, señora presidenta, y agradezco que esta respuesta también sea considerada como un documento y sea registrada en los anales de nuestra Asamblea. Gracias, señora presidenta.
I thank the representative of Venezuela, and I give now floor to Madagascar.
Bonjour. Déjà, nous voudrons demander si Madagascar fait partie des pays qui n'ont pas le droit de vote, car nous avons des arriérés qui ont été honorés ce mois-ci, juste le 26 novembre dernier. Parce qu'en effet, nous avons eu un changement de régime à Madagascar et nous avons honoré celui de 2024 et également de celui de les cotisations de 2025. Mais nous aimerions bien nous assurer que Madagascar fait partie des pays qui peuvent voter pour cette session. Merci.
I thank the representative of Madagascar for their point of clarification, and the list that I have in front of me does not list Madagascar as a country in arrears, and I can thus confirm that Madagascar holds the voting rights as other states' parties. And I would like to give floor then to the representative of Argentina.
Muchas gracias, señora presidenta, por darme la palabra nuevamente. Quisiera expresar que mi delegación rechaza en todos sus términos las expresiones agraviantes del delegado de Venezuela. La Argentina es y ha sido siempre comprensiva ante las dificultades financieras que establecen los estados partes de esta asamblea, pero no puede hacer caso omiso a la realidad de los crímenes que se cometen en ese país. En este marco, la actitud de Argentina de no interponerse a la voluntad de la Asamblea demuestra nuestro compromiso con la Corte Penal Internacional y una reafirmación del llamado a la Corte a tomar medidas concretas y urgentes ante la situación en Venezuela. Muchas gracias.
I thank the representative of Argentina. And I would like to stress once again the importance of ensuring that the court is provided with necessary financial resources. I encourage all states parties to pay their assessed contributions in full and on time, or in the event of pre-existing arrears, immediately, in accordance with Article 115 of the statute and Rule 105.1 of the financial regulations and rules. Distinguished colleagues, let us now turn to agenda item 11, election of the members of the Committee of Budget and Finance. Under this agenda item, there are 3 separate elections. First, election of 6 members of the committee. The 6 vacancies that will arise on the committee on the 31st December 25 upon the expiration of the terms of office of 6 members are as follows. African states, 1 seat; Eastern European states, 1 seat; Latin American Caribbean states, 1 seat; and Western European and other states, 3 seats. At its 6th meeting on 12 March 25, the Bureau fixed the nomination period to run for 12 weeks from 2nd June to 24th August. At the end of that period, since the number of candidates remained less than the number of seats, and in accordance with resolution ICC-ASP1/resolution 5, the nomination period was extended to 11th September and subsequently to 30th September and 20th October 25. As regards the election of members from 4 regional groups of states parties, since the number of candidates corresponds to the number of vacancies in the Eastern European, Latin American and Caribbean, Western Europe and other states group, and at its meeting on 8th October 25, the Bureau decided to recommend, pursuant to resolution ICC-ASP1/resolution 5, that the Assembly dispense with the secret ballot and elect the following 5 candidates by acclamation. For the Eastern European states, Mr. Urmet Lee, Estonia. For Latin American and Caribbean states, Ms. Ana Patricia Villalobos Arrieta from Costa Rica. For Western European and other states, Mr. Karl-Heinz Heller from Germany. Mr. Daniel MacDonald from United Kingdom of Great Britain and Northern Ireland, and Ms. Pascal Tomas Hernandez of Spain. Does the Assembly wish to elect the above-mentioned 5 candidates by acclamation for a 3-year term commencing on 1st January 26? I see no objection. It is so decided. I note that the 6th seat on the committee is allocated to the African group. In that, as regards that vacant seat to the African group, I understand that consultations have been going on since there are two candidates, and may I ask whether any outcome on these consultations has emerged? I don't see anyone requesting for the floor. I understand that consultations are thus still ongoing within this regional group in order to reach agreement on the candidate to be presented to the Assembly for election. I request the coordinator of the African group to keep me informed on developments regarding this matter. And in order to allow everybody to know, currently we have 2 candidates, Mr. M. Gilbert Raveloson de Madagascar and Philippe Neri Coulon-Nion from Burkina Faso. And as I mentioned, I request the coordinator of the African group to inform me during the course of this week whether a decision has been reached within the group. We shall thus return to agenda item 11 at a later plenary. Then we have a casual vacancy on the committee from the group of Eastern European states, which arose from resignation of Ms. Elena Sobkova from Slovakia on 7th of November 24. I wish to indicate that on 12th March 25, the Bureau fixed the nomination period to run from 17th March until 16th April 25. After 3 extensions of the nomination period, no nominations had been received. Therefore, on 17th July 25, the Bureau decided to reopen the nomination period for the casual vacancy allocated to the Eastern European group to run until 24th of August. And at the close of the nomination period, 1 candidate had been nominated. On the 8th of October 25, the Bureau, pursuant to resolution ICC-ASP1/resolution 5, decided to recommend that the Assembly dispense with the secret ballot and elect the following candidate by acclamation: Ms. Mateja Vranegigar Erman from Slovenia. Does the Assembly wish to elect the above-mentioned candidate by acclamation for the remainder of the term of the member who resigned, namely until 31st December 26? I see no objection. It is so decided. I congratulate Ms. Mateja Vranegigar Erman from Slovenia on her election to the Committee on Budget and Finance and wish her every success in fulfilling her important mandate. Then we have vacant seat pursuant to resolution ICC-ASP/22, resolution 8. As regards that 1 vacant seat on the committee allocated to the Eastern European group pursuant to resolution I mentioned on 12th March 25, the Bureau fixed the nomination period to run for 12 weeks from 2nd June to 24th August. At the end of that period, since no nominations had been received in accordance with resolution ICC-ASP/1/resolution 5, the nomination period was extended 3 times, ending on 20th October 25. Since no nominations were received for election to the seat allocated to the Eastern European group during the extended nomination period, the election for this seat will be held at the 25th session. I wish to recall that this additional seat was allocated to the Eastern European Group at the 22nd session by resolution ICC-ASP/22/resolution 8, which deals with the expanded CBF. On behalf of the Assembly, I would also like to extend my appreciation to the outgoing members of the committee, Ms. Sarah Lahail Yusu from Sierra Leone and Mr. Klaus Stein from Germany for their committed service. And as I mentioned previously, we will revert to our consideration of agenda item 11 at a later stage this week. We turn now to agenda item 19, other matters. And first there we have election to fill a vacancy on the board of directors of the Trust Fund for Victims. I would like to indicate that this item was included under other matters since I was notified on the 28th of July 25 by the outgoing member, Ambassador Tarek Muhammad from Bangladesh, of his resignation effective December 25, several months after the provisional agenda for this session had been issued on 3rd April. The Bureau took thus a decision on the opening of the nomination period at its next meeting on 3rd September 25. And for this election, I wish to recall that the nomination period closed yesterday on 30th November. The Secretariat has informed me this morning that at the close of the nomination period, one candidate had been presented for election to the one seat allocated to the Asia-Pacific Group. In addition to 26 November 25, the Bureau authorized me to recommend that the Assembly dispense with the secret ballot and elect the candidate by acclamation if, at the close of the nomination period, the number of candidates corresponded to the number of vacant seats. Since this is the case, does the Assembly agree that we would proceed to elect a member of Board of Directors by acclamation? I will, of course, mention the name once I see that the Assembly agrees to do accordingly. I see no objection. The Assembly will now proceed to elect a member of the Board of Directors to fill the vacancy for Asia-Pacific Group that arose upon the resignation of Ambassador Tarek Muhammad, Bangladesh, effective December 25. Mr. Muhammad was elected at the 23rd session of the Assembly for a 4-year term commencing on 6th December 24. On the 3rd September 25, the Bureau fixed the nomination period to run for 12 weeks from 8th September to 30th November. And at the close of the nomination period, one candidate had been nominated for election. And he is Mr. Oh Won from Republic of Korea. Does the Assembly wish to elect the above-mentioned candidate by acclamation for the remainder of the term of Mr. Muhammad, namely until 5th of December 28? I see no objection. It is so decided. I think we have this every year on the first Monday that we will have this alarm telling us that it is 12 o'clock. Very timely. On behalf of the Assembly, I congratulate Mr. Oh Won on his election to the Board of Directors of the Trust Fund for Victims and wish him every success in the discharge of his important responsibilities towards the victims of the crimes within the jurisdiction of the court and their families. I also wish to extend my appreciation to the outgoing member of the board, Ambassador Tarek Muhammad, for his committed service to the Trust Fund for Victims. Distinguished delegates, we have concluded our business for the first plenary meeting. We will meet here at 15 hours sharp to begin the general debate. I wish to announce that the Credentials Committee will meet immediately following the adjournment of this meeting in the Colorado room. I wish you all a pleasant lunch break and see you back here at 15 hours.